intellectual property attorney. As you mentioned, patents and trademarks, copyrights also falls into intellectual property. I have a very entrepreneurial spirit of getting into patents and trademarks. I got into this because I like to know how things work. I like business. I like figuring things out. And very early on, I kept coming up with ideas on how to do things. And I've had some ideas that have been home runs and have worked really well, and I've had some really huge flops. I've seen both sides of the business world, but one of the companies that I've helped to found that is doing very well is Persona Multimedia. Persona Multimedia works with probably most of your marching bands, helping them to get copyright clearances for the music that they play. We're the largest issuer of custom arrangement licensing in the world, and do a lot with copyrights on the internet, which is, I think, how Chris originally found me. We've had a lot of experience and had to go with an industry that was having problems with all of the marching band videos being knocked off and thrown up on YouTube to now getting out a little bit under control. I'm a founding partner with Udall. We do patents, trademarks, copyrights, licensing, and litigation, and any of that you may need. What I'd like to talk about today is I'm going to focus it on the needs, what Chris said, the needs with the All-22 content. But I think to get there, I'd like to give a little bit of a background on some basics of copyrights. What is fair use? Because that's the excuse everybody uses when you're stealing your stuff. What the liability is to them, and then go through some examples. I'll give the disclaimer. The lawyers always have to give a disclaimer, and it is in small print at the bottom for a reason. Don't go away from here thinking you know exactly what you need to do and try to sue somebody. Talk to a lawyer first. Every copyright issue is always going to be fact-based. The courts always weigh the facts with the rules that they have in copyright law. And so I'll give you some basic tools and hopefully you'll get a little understanding. I am not, however, going to be talking a lot of legalese today. I don't like quoting laws and statutes and things, but if you do, you can look them up. What's a copyright? So a copyright is protection against copiers. Copyright gives you, like what it says, copyright gives you the right to copy and the right to prevent others from copying what you've done. It specifically protects expressions of creativity. So it doesn't protect your ideas. If you come up with an idea that says, hey, I think this is a great way to film something, it's not protecting that idea. What it's protecting is your actual expression of your creativity. The expression doesn't have to have even that much creativity. To give you an example, with video, even just pushing the record button is enough to have ownership in that copyright for the recording. Because you had to, at some point, decide what angle you were going to shoot, what width, what focus, what color settings, all of that goes into the creativity of that. So copyright protects your ability to prevent other people from copying what you've got, what you've created, your expression of that. Who owns it? The general rule is whoever created it, they own it. So if you are the person that hit the record button, you own it. And anybody that does anything with that after you needs your permission to do something with that, with a few exceptions. If you're an employer, if you're an employee of a company, for the university, for example, and you're hired to make that recording, what you're creating is a work for hire, and the university or whoever your employer is owns that. If you're a contractor to the university, and there's a contract that says that you're doing it as a work for hire, then the university would own it. Otherwise, the contractor owns the rights to that video. If there's very much more of this. So, or you can sell your writing video to another person to a contract. You can only transfer ownership. So the ownership, however it sets up at the creation of the work, can only change if it's done in writing. So just somebody saying, hey, if the contractor comes to the school and says, hey, I'll do this recording and I'll let you have it when I'm done, does not mean that you own it for the university. It needs to be done in writing. So get some sort of a simple work for hire agreement that you can find them on the internet, because they're all over the place. But get something that says it's being done as a work for hire, and that way the university will want it. Who can use the copyrighted material once it's done? So once something is created, you know who the owner is, because that was either the creator or the employee, or the employer of the creator. Who can use it? This picture right here is part of the reason that the copyright law changed in the last 15 years. Steamboat Willie was created in 1929, and the law at that time said that, and the law up until 1999 said that copyrights go for 70 years past the death of the author, whoever created it, or if you're a corporation that owns it, it's 70 years past the time it was created. And in 1999, it was hitting 70 years for Steamboat Willie, and Disney went in there and said, wait a minute, we're going to lose the rights to Steamboat Willie, and we don't want to do that. We're still making money off of this. And so they went, they petitioned Sonny Bono and had him go to Congress as a senator and convince them that they should change the law. And it now is 95 years from the creation of it. So they've got another 15 years on the end until their copyright expires for Steamboat Willie, and they will probably go back in and petition again to have it extended. The owner can use the copyrighted material. They can do whatever they want to with it. The copyright rights that it protects includes the right to make copies of it, obviously, the right to display it in public, the right to let other people use parts of it to make other creations if they want to, the right to use it to promote events, anything that involves showing it to other people or using it in anything, the owner gets to control that. He can give permission to other people, usually through a contract, but it can be verbal when he's giving this permission to use. He can give permission to other people to use it, or fair use. And fair use, anytime you've got an infringer, the infringers always say, it's fair use. That's why I can use this. I'm not making any money on it. You hear a lot of different reasons for it. I'm not making any money on it. I'm really not hurting anybody. It's out there. Why do you care? I'm just promoting what you're doing. By me showing it to all of my customers, you're getting publicity, and so that's to your benefit. Why are you complaining about this? Fair use, however, if somebody gets sued for infringement or accused of infringement, they can use fair use as a defense in that. And there's 4 factors that the courts use. This is where they're weighing what is fair. The 4 factors are the purpose and character of the use, the nature of the copyrighted work, the amount, the substantiality of the portion used, and the effect on the potential market for value for the original. The purpose and character of use. What the courts are looking at specifically in that case is the use that the infringer is doing, the accused infringer, is that use a commercial use or a non-commercial use? And is the character of the use such that it completely changes the original so that it's really a brand new work? Or is it just a derivative work? Derivative meaning it's a subset of what the original was. Let me give you some examples. Commercial versus non-commercial is fairly straightforward, but if somebody is putting up a video on a website and that video itself isn't being sold to anybody, but they are getting advertising revenue off the website, that's a commercial use. If the case I can think of where it maybe is not a commercial use in that sense is if it's just somebody's blog. and you've got some person that's decided they want to comment on videos or pictures or artwork, and they put it up there and are just, there's no advertising on the site, it's just their rants and ravings about the transformative. The examples that are typically given for transformative use are, like, say, a video mashup, where you've taken a whole bunch of different video clips from different things, squished them all together in one big, long video that isn't for the purpose of the original video. It's not to show, well, using football video as an example, it's not to show the All-22 with how the plays went and succeeded one after the other. It just took a bunch of maybe bloopers from it, or took those parts. That would be something that's transformative. With all of these factors that are used in here, it's not, you don't have to have all of the factors in your favor to win. You only necessarily need one, but because the court is weighing the balance of fairness, the more you have in your favor, the better chances you have of winning. The first one, however, this one with the two asterisks, is the most important one. That's the one that the court's weighted heaviest on. The nature of the copyrighted work is not that. The nature of the copyrighted work is what was it that was copied. If the thing that was copied was somebody's layout, so somebody arranged the names and numbers on the directory in a particular way, that's not that critical of a thing. There wasn't a lot of creative input that went into it, and so the courts would give that much lower value or much lower benefit. If, on the other hand, it's the Mona Lisa, the courts would give it a much higher one. On the next one, the amount of substantiality of the portion used. Did they copy all of the work? Whatever it was that was created originally, did they copy the whole thing? Did they copy a substantial portion of it? Did they copy the heart of the work? As an example, if you think of the Darth Vader theme, da 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 da, that's only one measure, 1.5 measures, a really long song, but that's the part everybody recognizes. If that's the part that was copied, even though they only copied a little part of that song, that's infringement, because that was the heart of the work. The same with the When You Wish Upon a Star. Everybody recognizes that first little part, because Disney has made a big point of making that recognizable part. Or maybe it's the smile on the Lisa, to use that as an example. If, on the other hand, somebody took a video and needed a picture of a football video, needed a picture of a football helmet, and so cropped out a little section of that football helmet off of the video. Probably not the heart of the work that they got that helmet off of that video. If, on the other hand, they copied some critical plays that were in the game, that might be. The next one, on the effect of the potential market of value, the question they're asking is, does this compete with or diminish the value of the original work? So if somebody has created Steamboat Willie, for example, in this video, and they're selling videos and they're using it to market their business, and somebody starts knocking that off and selling CDs in the United States, Disney's going to say, wait a minute, all of those people that are buying that are buying your DVDs, are not buying our DVDs, or they're not going to our website to see it, or they're not going to our YouTube channel, they're not going to Disneyland to be able to see those things. They're getting it from you, so you are in direct competition with us, and you're diminishing the value that we have in our video. The reason diminished value is important, I think, relates to the All-22, in that it's not necessarily being offered for sale to anyone, but when other people are swiping that and putting it out into the public, it diminishes the value of those videos to the person who created it, or to the university, because that information is now out, and maybe it's not information that you want to get anyone else. Examples where it is probably fair use. Again, it's always you've got to weigh the facts. So it's always one of those, but first example, if somebody is just commenting on or critiquing the copyrighted material. This is where the news exception comes in. People talk about the ones they typically talk about is a news exception and an education exception. Just because it's in the news does not mean they're random acts. And just because it's used by a teacher or used to educate somebody does not mean that it's getting passed. It has to fall within these and still meet the balance. So if somebody's got copyrighted material, they take a small section of your video and they put it up on the wall, and then they comment on the content of that material, or they report on just the content of that part of it, they're probably going to fall under a fair use exception. If, however, they copied substantially all of your work, or they copied the critical parts of it, put it up on their website, and they put something that says, hey, this is up here, I think it really wasn't recorded very well, or I think this football game could have done better, that's not going to be a commentary or critiquing the copyrighted material enough to improve that. Using the copyrighted material for education, for example, this is what typically is used as the education exception. In schools, they talk about copyrighted material all the time, and they use them as quick examples to educate the students to say, hey, this is out here, and you should be aware of it. That's okay to do. What's not okay to do is, being in the collegiate field, you would understand. If the teacher says, hey, look, I know you made this textbook from the students, but we decided we're not going to buy it from you, we're just going to photocopy it, and we're going to digitize it and pass it out to the students because it's cheaper for us. It's an educational use, so it's okay. It clearly is not going to be okay, and people that went to the work creating that aren't going to be happy. That's not just using it as an illustration or example, that's actually copying the entire work and stealing it instead of paying the person for it. Capturing the copyrighted material incidentally or accidentally. This is something where you probably are familiar with it. If you're in the stadium and you're videotaping and you catch the audience somehow. The audience has t-shirts on them that have designs on them that are copyrighted. The banners that are around the stadium will have logos or artwork on them that the advertisers put on there. That incidental capture of that is okay. It's not, that's considered fair use. If you were to make a video that focused in on that particular piece and decided to focus your video around people that have t-shirts that have particular artwork on them, that would be a problem because it wasn't just incidental or accidental capture of that material. It was actually that was your focus. The last two are related here. Reproducing, reposting, quoting to preserve content, and copying or reposting to launch a discussion. These two were added more when the internet came up, and all of the different blogs and all of the different tweets and Facebooks and everything that gets posted and reposted, so that everybody that perpetuates whatever it was that was started at the beginning, that's okay. You don't get in trouble for reposting or sending things on. The original person may get in trouble for initially posting it, unless the purpose was only for the purpose of launching a discussion. That one, we'll leave it up to the person to figure out how much you have to do that and send it there. This one comes up where you're. I think this one relates a lot to the critiquing commentary, but where you're doing a collection of small parts of other people's work. So if you're doing a quote of somebody in your book, you're writing a book about some topic, and you quote somebody that said something, you take a paragraph out of their book, or you take a paragraph out of somebody's article or somebody's speech, and you put it in there to make a point in your book. That's okay to do because you're combining elements from your new work that's created. It fits into the transformative nature. If, on the other hand, you're creating a collection of poems or poetry, you would be copying their whole poem and putting it into your book. not transforming it in any way, you're not doing the whole thing. So that kind of thing. So these are the typical places where you find exceptions to fair use. The reason I'm going through all of this fair use comes up when we're going through the examples for All-22. What happens if you infringe? So if I infringe somebody else's copyright, we now know who owns the copyright, we know what can be done to transfer that copyright. If they haven't done that, it hasn't transferred. We know who is allowed to use that copyright, or if somebody uses it and claims fair use, we can tell whether they are using fair use or not. What happens if we find out that somebody's infringing what we've done? The owner of that copyright is entitled to actual damages. What is it? How were they damaged? If the damage, if you are creating a home video and you put it up on your YouTube page and somebody else takes it and puts it up on their YouTube page, you're probably not damaged at all. Nobody's harmed by it. Your damages would be that you get to make them take it down. If they got any profits from that, you get your actual damages, plus you get the profits that they have. So if they, on their YouTube page, had some advertisements out there, and they were getting their 41 cents for every 1,000 views or 10,000 views that YouTube gets, you might be entitled to get that. Sometimes when those videos go viral, the money can get substantial. Or you get the choice of that, or you get statutory damages. Statutory damages requires that you actually have your copyright registered. Registering a copyright is a really easy thing to do. We'll talk a little bit about that in a minute. Registering a copyright is $35 to register the copyright. The Copyright Office site has really clear forms that tell you exactly what needs to be put in. Easy to follow, easy to do. The statutory damages are anywhere from $750,000 to $30,000 per work infringed. So if you are making your All-22 videos and you're creating one video per game, each video that gets copied by each infringer, that's what your potential damages are. Unless they are doing it on purpose. If they know that what they're doing is not fair use, and they don't have any reasonable arguments why it should be fair use, then it's up to $150,000 per video. Even if they copy it 1,000,000 times, it's still $150,000, but that goes into the nature of the copy. So the damages can be significant, particularly because usually on these websites, they're copying videos and selling videos. It's not a huge profit they're making on these. They're not selling hundreds of thousands of copies of these videos. They don't sell them a few. And so it can be significant to their for considering whether it's willful on 150,000 fines, the courts assume that it is willful unless the infringer proves that it wasn't willful. Okay, All-22 content examples. What typically happens, as I understand it, and somebody here can straighten me out if I'm wrong, videographer records you're up above the press booth, somewhere up on the top, and you record your All-22 footage. The footage gets to do whatever editing, you upload it into your system, it gets delivered to the coach, and you give copies to some of the other teams. Of course, even if it's copies of the wrong footage. And somehow, the footage and the images are ending up on websites. And somebody knows how they're getting there, but nobody's coming out and saying, here's why they're ending up on the websites necessarily. The question that we have then is, what can be done about this? Is this infringement? Is what they're doing with it infringement? And how can we stop it? As I looked around at the different sites, it looks, the ones that I was told about anyway, they all look like they are commercial sites. They've got advertising up on their blogs, or they're outright selling the All-22 footage. And and charging $110 a game, or charging, there was some of the, like the subscriptions, you can continually go on there and watch all of them. They've made it a really good commercial enterprise. So there's sites looking at whether this is infringement or not. Sites where the videos are sold. So if the person has some sort of a contract with whoever owns the video, they can sell the video. If they don't have a contract with them and they're just getting the video from some other videographer, from some guy in the locker room that receives the video from the videographer, gives it to the coach, and then slips a copy out the back door, if they don't have permission from the owner of the copyright and they're selling it, it's going to be infringement. It's definitely commercial. They're not transforming any of these videos in a way that would be like a video mashup. They're just taking that video, or they're taking large clips of the video and they're putting it up for sale. They're copying all of the critical parts. Even if they're cutting out anything, they're just cutting out the sideline views, they're cutting out the parts that aren't critical for the game, because the value of those videos is in the action. Competition. So as I was looking at this, I thought, well, if we're not selling the All-22 videos to him, are they really in competition with us? And that's where it comes back to the not directly in competition, but definitely diminishing the value of those videos for us, and it's our material. Even if the court said, well, if they're not competing, you're not selling them anyway, so why should you care? You don't have to have all four of the elements. The most important one is, are they doing it for a commercial purpose, and are they transforming So that would definitely be infringement of those. There's sites I saw out there that just display it. YouTube's an example. I've seen several videos online that are all 22 videos that somebody puts up on YouTube. So are those sites infringing? They're definitely commercial. Again, non-transformative. They're not changing the videos when they put them up there. They're just putting up sections of the footage. Even if they were to add the lines on there, that's not going to be enough of the transformative. That's just adding information to it. They copy all the critical parts. And again, it doesn't necessarily need to be in competition. Even if they're not selling this, they're getting advertising. YouTube's getting advertising from it. And so it is a commercial use and would be copyrighted. The last type of site that I saw were commentary sites, blogs, places where somebody's put it up there and then made some comments about it. And I didn't find one where they put up a whole video and then made some trivial comment about it, trying to make it blog. The ones that I saw had image clips out of the video, and then they would comment about something, or they'd have a short little blurb about it and comment about it. So definitely commercial. All of the sites that I saw had advertising on them. Transformative, if they're just putting a big video clip up there, not transformative. If they're putting smaller video clips up there, again, not transformative. But on the ones where they didn't put a big large clip on there, they only put a small section of a clip, it may not have been a substantial portion of the copyrighted work, but it was definitely part of the copyrighted work. Competition, same explanation of competition. The sites that were the blog sites, where all they did was take a small chunk of it, though, I think that they fall into the exception, the fair use exception, as being commentary and using it as illustrative examples. That kind of use probably is not going to, you wouldn't be able to win on copyright case because you're just taking a small section. I do, however, have an answer for that. Yeah.
That would be fair use of commentary plus the use of a small section of video.
Yes.
But do they run into a problem because of the inclusion of the advertising in their commercials?
No, so just being commercial use does not mean that they get there, even if it is entirely commercial, copy everything that you've got, all of those. If they fall into one of the fair use exceptions, then all of that disappears. But the fair use exception is going to have to be a really strong one if they're really heavy on all of these things. So if it's like these sites, very definitely a commercial site, but they're going to be arguing is, look, this is news. We're commenting on it. We're providing information. We're not taking the whole thing and just slapping it out there for everybody to see. We've got a specific point to make with a specific point. So, what can we do with infringers? First thing, and we would love, there's all sorts of things we would love to do. Unfortunately, I'll give you the comments here and then the steps to take. But the first thing to probably do is to contact a lawyer. Call the university lawyer, call the football teams have their own lawyers that they use, they probably do. Call them and just ask them their opinion on it to see what they say. What they're going to tell you to do first, they're going to say, okay, let's decide whether it's infringement or not. If it's somebody just taking all the videos and they're selling them online somewhere, definitely infringement. We go through that same kind of evaluation we just did. Consider what the damages are. If it turns out that the damages are only going to be $200 or $300, and you're not suffering, the football program's not suffering too much about it, the lawyer's probably going to say, look, that was a really expensive thing to do. Are you sure you want me to spend all the money trying to figure out that problem for you when it's really not going to make that much of a difference to the program? I'll tell you though, we found with the marching band videos, but those were coming up, and it wasn't because somebody was taking the video that was created, it was because people were in the stands videotaping all of the marching band performances and then putting them on their websites and on their YouTube channels. What we found though is that when we went around to them and said, hey, that is the property of the university, you need to take it down, and we got them to take it down. All of that traffic moved over to the website for the marching band. All of the advertising that they were doing now started to generate tens of thousands of dollars in revenue for them, and it made it worth money. So if you've got some other commercial outlet for the videos, it would be a lot better than what you're doing is just trying to keep them secret. But even if you're just trying to keep them secret, I'm sure those coaches, if they want it secret, they want it secret. You then send a cease and desist letter to them. You contact them and say, hey, knock it off. This is our stuff. You didn't get it legitimately. I don't know how you got it, but you shouldn't have it. And it's copyrighted. You need to stop or we can't come back. If they then don't stop, there's takedown procedures. YouTube has takedown procedures. Google has takedown procedures. GoDaddy. If it's a site that's handled by GoDaddy, and a big chunk of it in the world are, even outside the country, a lot of people handled by GoDaddy, you can go there and say they've got copyrighted material that they're stealing, I need to take it down, and they will do it. It's a bunch of groups to come through and if they're selling things, you can get those things on that too. And then the lawsuit. The lawsuit is the last resort. You don't want to get there because it gets even more expensive. A lot of these small groups, though, once you start threatening a lawsuit, they back down really quickly because they're not making money. And they'll tell you all along that they're not making any money, but it's enough for them to kind of run a business. So they start the lawsuit often, they back down. The ideal copyright case, and this is where we kind of talk about the best practices. What should we be doing? How can we do this differently? First thing is to mark the videos with a copyright notice. Even if it's on the outside of your video cassettes anymore, but if it's on the outside of the disc, I don't know how you transfer those files. But having a copyright notice on it. The copyright notice on it helps them to remember, one, that this is copyrighted material, two, that you don't want it copied, and it helps when you're going to see calculate the damages if you've given them notice before you copyright sealing. copyright notice isn't required in the United States, it is in some other countries, but it's better to have it on there than not. If nothing else, than just to give them notice. You can register it, especially if you see that somebody has stolen one of the videos that you want to have protected, register it with the Copyright Office. That you can wait until that last minute and register it. It changes the damages calculation, but if you don't want to have to register every single one of the ones that you have, you just round up the ones that are being copies, you can do it that way too. The next thing is when you're passing those videos off, a reminder, even if it's a form paragraph, you stick in the email if you're emailing these files, or if it's something that the paper that's tucked in the sleeve of the DVD, if you're handing a DVD, something that says this is copyrighted material and you're not supposed to pass it off to other people. That helps, and it again reminds them it would help in the report if you say, look, we marked it with a copyright, we registered our copyright, we gave them notice and reminded them when we handed them the video that it wasn't supposed to be spread off to anybody else. All of those things help to weigh in your favor when the judge is balancing the decision of whether this is fair use or not, and whether you have the requirements for showing this. Competitive use. So we've said that, okay, it's competitive use or diminishes the value. If you have an actual use that you're making of this, that you can say to the court, look, this is our use for this, and their use is in competition with us, that can be a value, even if, and I don't know how in your industry it works, if the coach certainly doesn't want the most recent games, or maybe even this season's games out in public, but maybe you've got 3 and 4.
Okay.
Maybe you've got 3 and 4, and 5 years ago, all of the archived videos were this All-22. If you can create a place, an outlet for those, so that anybody that now is putting out the current videos is competing with your future use of those as part of your archived videos that you're looking at. Maybe it's when the coach changes, the new coach doesn't care what the old coach was doing, doesn't care what the players do for the old coach, so you can release all the videos from the old coach out. I didn't see any of these sites now, unless maybe that's where some of these sales sites were at, that I didn't see any sites that seem to be collecting the videos legitimately from the schools. But if not, somebody maybe wants to create that, and they'll legitimately get permission from the owners of those videos to be able to put those up and create an outlet. That would assist in the competitive use argument on it, and definitely is convincing to the judge, and you say, look, they're stealing our stuff and taking the business away from us. Are there any questions?
Well, I actually talked to one of the guys for a little bit, and the way I understood it is he would request film from schools. So whether it's Minnesota or TCU or LSU or La Tech, and I know of almost no college coach who's going to tell a high school coach, no, you cannot have this film because they have something that we want. They have recruits. Okay. And so then afterward, we're like, yeah, go ahead. But it's the problem of we give them the film, but we're not asking what they're using it for. It's some assumed use that it's going to be for their learning, not for their redistribution. How can we, and then the other part of it, you're saying about releasing film, I had a question on that too, is my coaching staff might leave, but it might be where Penn State's coaching staff is still there from that same time period. Do they have any ownership of that film, even though they were not the ones filming it? They were part of the process of why it was filmed.
They were going to be, yeah. Okay, on the first one, the way I would, 2 possibilities for how to handle it. The first way is the preferred. The preferred is, Coach, we would love to give you a copy of this video. We really appreciate the recruits. We appreciate you sending the kids up to us. here's a copy of the video, I just need you to sign this one paragraph thing that says you understand that it's for your review and not release or nothing else. That's the ideal, especially initially, then they look at you and say, I don't want to sign anything, but if it's simple enough, it just says, I understand I'm not, it's for my review, not to send out. They shouldn't have a problem. If they don't want to sign that, at a minimum, having a paper or electronically send it to them, send them a notice that says, hey, this is not your material. You should not, this is for your review purpose only. You shouldn't send it out to anybody else.
Okay.
But if you know of anybody else that wants a copy, let us know and we'll be happy to copy. And that at least puts them on notice that it will significantly reduce the cases of these now and something on the other question of what about Penn State's coaching staff? They actually don't have any rights in the video. So from a legal standpoint, unless there's some contract that I would doubt that there would be, there's no problem with sending that video out as long as the owner says it's okay to send out. But it may not be for good regulations if you're sending out their videos. That's why I was thinking after it's a few years old, maybe there's some.
You were talking earlier about you don't know of any companies out there who are getting all their video along. I get an email from this guy almost every single day. It's footballvideos.com.
Yeah.
So there is a guy out there.
Yeah, this is the site that I saw up for sale. That he's selling the videos.
Yeah, $50 a game right here.
Yeah.
So I mean, he's been going for. We sent in a cease and desist letter probably about 9 years ago.
Okay.
So
nobody's stepping up and making stop.
no, I mean if you go on there and you look at like video catalog, I pull up any of your guys' schools, he's got stuff. You would be surprised how this guy's catalog is
Expansive.
How much is he paying to get the videos?
So the way he explained it to me is that he reaches out to Matt, let's say at Minnesota, and Matt says, yeah, sure, we'll do it. So he sends you a contract for every game that he sells. He gives you a percentage of that sale back to your school. So he markets it as a way to make money for your football program.
Okay.
So he's not kind of trying to be sly about it and stealing people's video. He does it by signing contracts with universities to then turn around and give money back to those schools. But from my understanding what you just said, so if he signs with Matt and Minnesota gives him every single game that he has ever played against them, we have no protection, we have no say in the matter because it's like copyright laws, it's Minnesota's game, not ours. Even though we were involved.
That's right.
What happens when, sorry, go
He
ahead.
just signs the agreement with Matt, though.
Right.
Matt doesn't have any authority to do that. So if he just signs the agreement with Matt, then it's the university that owns the copyright, and Matt doesn't have the authority to get him to sell those games. But if, assuming Matt got permission from the coach and from whoever needed to have the university and that would be legitimate use and not.
Doesn't the Big Ten own the rights to, you can't sell that in the school?
Correct. The Big Ten owns every piece of video in the shop, whether it's by coaching camera, television, on field ground highlights. Big Ten owns everything.
And I'll bet the tickets, that backside of the ticket that everybody looks at says, hey, you're not allowed to videotape things. So Big Ten would then need to be the ones in contract with them. And Big Ten could go back after him and say, hey, you're properly stop. If the grant is
So at that point, the Big Ten plays the nation system, we have the same. Do at that point.
It depends on what his contract says. It all comes down to who owns the video. So if their contracts say that they will pay Big Ten, stadium, they handle the ours, maybe control and it may be the control, and in which case either of them.
The slightly awkward thing with All-22 coaches footage is though if I'm playing Cincinnati, we're standing next to one another. Filming. Like, he may sell his copy, but, I mean, there's,
Yep.
are you SOL because you can't tell who owns it?
I can see, and here's the thing, because I saw there's TCU film up this year, and our game was up there because they murdered us, and I could tell it was Maple's copy. I could just tell by the way it was edited. I went back and I compared the footage real quick, but I could tell just by the way it was it's not my stuff. It's Mike Maple's stuff.
And so there's also, and I don't know all the process that you go through. One of the things that we did with the marching band videos is we put a watermark. So we just put a little watermark in the corner that was kind of like the copyright notice of the logo. We did it as a promotional thing, but the copyright notice so that everybody that gets a copy of that knows that it's not.
You guys know better than me. I know the last couple years when we played at Oklahoma State, ESPN plugged an SDI into our camera, so they would have that for replays and stuff. And they used it, I think, like 3 times last year, a couple long passes or whatever. Free plays or whatever probably isn't a problem to show on TV. You guys do that anywhere? You guys let ESPN plug in your cameras?
Yeah.
Like,
ESPN, BTN, CBS.
And you probably have a license with the stadium or the conference or whatever that says we've got a license to use whatever video.
Well, it's also a give and take. We give them all free suit, they give us the notes. I mean, they give us the TV copies, even though we're fucking getting it. It's just one of us helping each other out. I know. It just makes it easier.
Trade-off there. I know like the last couple, I don't know if Oklahoma State's cameras doesn't have the SDI.
Yeah, it doesn't have.
Not
Every time we play, they use
Yeah,
all.
I just do, we play there, they use ours, not Oklahoma State, so I'm sure why they didn't use theirs.
All right, mine's kind of off. But I'll make a highlight so you can we'll talk about that. And that's it.
Not even this. You can get sued for, so anytime you include somebody else's copyrighted material with yours, you can get sued.
Even if I'm not.
If you're not
You
selling
don't put
it,
it out, critical, you put it out.
So commercial or non-commercial, we can go through the same steps, but it's, yeah, you're
So Will, NAV or Norris taught me this a long time ago. There are companies that have negotiated with music companies to be able for guys like us to purchase that music to use on our highlight stuff. And that's really the only way I've ever found legally to be able to do that. And then, they go to the record companies, they go to the artists, and they purchase rights for a fee, and then they pass that fee back to us to use that music.
Does any of that fall underneath the university's ASCAP license?
So the ASCAP license, ASCAP, BMI, CSAC licenses allow you to have the music performed in the stadium or on university property. It doesn't allow you to synchronize that music with video images and record.
So like
It doesn't let you create a video.
So like intro videos on our scoreboards, it's technically.
If you have created a copy of that with the audio and visual together that you're playing, if you just had a video, and you played the audio separate, that's good. So that's the distinction of that.
So what Will was saying when like you put rap music on highlight videos and so forth. So I understand the initial value of that song. Something I ran into a couple years ago is I got dinged on YouTube by using a Japanese song in a video that I had. Now they shut down my entire YouTube account over that.
Yeah.
And what I actually learned after all that happened is that particular song was not allowed for distribution within the United States. So how do you claim diminished value or damages from an international company that has no plans on releasing that or even making it available to an international audience?
So the argument that I would use if I were representing them is I would say, well, you made a commercial decision that you did not want to release outside of Japan, we wanted to keep it exclusive to Japan because we believe that was a greater commercial value to us. And this person has now released it over in the United States without our permission, and that is damaging whatever we thought was the like that's what I would not consider not. Otherwise, we think that they want to get released everywhere.
Well, and that was the curious thing. They actually had a music video attached to that, but you could only view it in Japan. If you try to view it in the United States, you'll get blocked on YouTube channel saying not available in your country.
Yeah.
So again, I don't understand what kind of, again, damages it would be if they weren't even intending for you to hear it in the first place, which I know sounds odd given the way YouTube and the internet works, but.
I guess on a region like that, because all of the music rights are very country specific. That whoever the promoter was that did that, put together that recording, and put it out there, was only limited rights from the artist here in Japan, and they didn't want to put out anywhere else because that was so that was yes.
Back to the commercial music use, if someone does decide that they're going to go after us and sue us, are they suing us personally or are they suing you personally?
Depends on how you used it. If you used it in a video as part of your employment, your highlight reel, they're going to go after the university because they don't want more money. If you created it for your son's birthday party, you're going to go after the university.
I was watching Bill Barnes show several months ago. We had a recording artist on there, and they were talking about Spotify. And this recording artist in particular refused to sign up with Spotify and said that that company was destroying the world music market. And the way they made it sound was that because Spotify is a free media, any music that is played on there can be used in a public environment without paying any copyright fees on it because the artist has already released it to Spotify. So, and that's why this artist refused to sign with them because of that license agreement. He says these artists are losing millions of dollars because the second they allow their song on Spotify, their copyright protection goes out the window.
That's he's misunderstanding. There is a situation if an artist releases a song to be played in public, then anybody else can do cover songs of that and record those cover songs. That's the only case when that kind of a thing happens, or once you step over that line, it's open to everybody. But anybody that does a cover song of that still has to pay the artist for the cover song. It's 9 cents a cover. But the thing that Spotify is doing that's hurting the industry is that because Spotify, and there's several other versions like Spotify, because you can get access to that music anywhere, anytime you want, whatever songs you want, whether you're buying or downloading. That's what's hurting it, because you can access it anytime you want. So why you can buy that data copy of iTunes? Why you get that song over there? So that's why a lot of artists are not allowing Spotify and those people to play their music, because they want to still sell their music.
I purchased a license-free or royalty-free song from iTunes to use for a signing day. Since I purchased a license-free song, am I able to reuse that on YouTube legally or not?
Probably, it depends on what your agreement says. It may, some of those license-free ones or the royalty-free ones are royalty-free for non-commercial use. Some are royalty-free for commercial use. YouTube also, probably 8 or 9 years ago, YouTube got in a big fight with Universal Music and Sony, EMI, and because everybody was uploading all this music on YouTube, and the publishers weren't getting paid for it. So they sued, the court finally made them settle into an agreement where the publishers would get paid every time. Publishers can track the whole thing, they can notify YouTube, and then they can get paid for it. And so that was the settlement that came up, and that was forever. The problem that they've run into with that, though, is that there are, what is it, every minute, 24 or 48 hours worth of video that's loaded into YouTube. Nobody can keep up with the fingerprinting software that YouTube has on there to track all of the videos and the music that's being used. It's spotty. It's so. We tried to use it with our stuff, and it came up with maybe a third of it, so it's not very well. So the publishers are not happy with the agreement, but it's that's
Years ago, there were a couple of court cases I heard a little bit about, basically, it was a circuit court, or it wasn't just a circuit court. Basically, it sounded like they basically gutted all of the protection on it. Oh yeah, you can just go out and grab a little snippet of this, a little snippet of that, and come out with a basically really
I'm not sure which case specifically that one is that you're talking about, but it would fall into that. Is it transformative? Has it completely created it into something new? And did it take the heart of the work? So if you took all of the main parts of all of the songs that everybody recognizes, and put all of those into one series, the court's going to weigh out, was it enough of a change to be like a video or music mashup? And did it take the critical parts of it to make it replace the original, essentially? I would guess on that that the court would say it didn't replace the original, because if you want to hear Lady Gaga song, you're not going to find this mashup of all Michael Jackson or Beatles. You're going to find Lady Gaga. Yeah.
As far as watermarking, you have to watermark the entire video, or do you put it in the first snippet and that counts?
I would think that counts. It's whoever's going to get that chunk. If you watermark the whole thing, all the better, but watermarking is not take enough. Whoever got that video, looked at that video, maybe missed it.
Just to understand what you said earlier, sorry, like songs that are on YouTube. So it's now that publishers understand that they're in way too deep. There's no way to even penetrate getting all of it, so there's no point even investing the time in it. What about when there are highlights of, say football highlights on top of that? Does that kind of go into that same category where they're not even going to mess with it anymore because it's just the same thing except now there's highlights over it?
No, so, and when you're talking about the highlights over it, you're talking about.
All I'm saying is like,
synchronized with the.
yeah, is there a difference when someone's putting up their own graphics with a song under it, compared to just, someone putting up football highlights with the same thing, just on YouTube?
As far as the public music publishers are concerned, no, and it's not that they are just putting up on it.
Sure.
They will still track it down, and you'll see them all the time, these songs get pulled down.
Sure.
Anytime the automatic fingerprint software catches them, they'll ask for them to take it down. They're getting smarter with that. But if there's whatever it is that's synchronized with the music, they can pull it. So, sure. But if you have your video that's showing up on YouTube as a highlight, and it's the All-22 coaches video that you created, that's something you've got copyrighted, you can go say YouTube, we need that taken down, that's copyrighted. I think that might be it.
Thank you very much. Thank you.